in. We have an exciting topic to discuss today, just live updates as well as a few key immigration changes. So please join in and share the video with with your followers. I'm sure there are several people who are looking to hear more about what's happening in U.S. immigration. So do them the honest. Okay, so today we're going to be discussing a lot of live updates and we'll be taking questions as well. So if you have questions, stay tuned, listen in, and then we can have a good discussion. All right. So let's get started with this. Let's jump right in. We were reviewing the new district court ruling that blocked Trump's, executive order that he intended to use to end birthright citizenship, automatic birthright citizenship. The judge, I believe he's called LaPlante, in the U.S. District Court of New Hampshire, he issued his ruling last night, a 38-page ruling. So we're reviewing it. We're going to be reviewing it in this video. So ask your questions and hopefully we can answer a few of them, getting to the end or towards the middle of the video. All right, guys, if you can see me and hear me, please drop USA, USA, USA. Type in USA or use the US flag. Drop in the emoji of the US flag or type in USA. I want to see you type in across all the social media platforms so that we have the go ahead to get started. All right, so let's give a bit of background. As you guys know, January 20th, 2025, President Trump issued executive order 14160. The executive order was entitled Protecting the Meaning and Value of American Citizenship. And it had, they had been combating, the US government had actually been fighting against US birth tourism. And especially I believe that was the main driving force that led the president to this point, because he had condemned birth tourism on numerous occasions in the past. Birth tourism is where foreign nationals come into the US on a B visa, for example, a B tourist visa, B1 business or B2 tourist visa or B1, B2 tourist visa. And when they come in, their main goal or their primary goal is to give birth or to deliver a baby so that the baby can obtain US citizenship. That's the main goal, just so the baby can obtain US citizenship. And essentially, the Trump administration spoke really harshly against this trend. And when Trump was president during his first term, they actually updated the US Foreign Affairs Manual regulations. They said that this was an illegal act to come into the US on a B2 visa to deliver just so your baby could get a US citizenship. So if you were pregnant and you were coming into the US, you had to show that you were not coming for birth tourism. This doesn't mean that if you are pregnant, you cannot come into the US for medical treatment. You can still come in for medical treatment. Oh, I'm sorry. Instagram says they can't hear me. Thank you so much. Because now, let me just pull, let me just connect the microphone. Thank you so much for that comment. That's why I tell you guys, drop me USA if you can hear me real good. I thought some people could hear me. Can you guys hear me now? Is it good, Claire? Please confirm if you can hear me. USA, please type in USA or drop the US flag in the comment section so I can be sure I'm not just talking into the air. Oh, okay, okay. Others say they can hear me. Can you guys hear me? Please confirm you can all hear me and see me well. Type in USA or drop the US flag in the comment section before we get into our conversation for today. All right. And so, they spoke against it. And when Trump came into power in his first term, there were regulations against it. As I was saying, this doesn't mean that if you're a bona fide medical, you're pregnant and you're coming in for medical treatment, it's disallowed. It's fine. That is allowed. All you need to show at the time you're going for your US immigration, your US visa, is that you have a medical doctor in the United States that is willing to work with you. You have the anticipated cost of your delivery, you have the money, the funds to pay, and you're able to show that you cannot get that same treatment, or there's something you're coming for in the US relating to medicals that perhaps is not available in your country or surrounding countries. Those are some of the things you show. And then the US embassy will give you a visa for you to come in for medical purpose, and then you can deliver. In that instance, your delivery or giving birth in the US is not solely to obtain US immigration benefits or to obtain US citizenship for your baby. It's because you're coming for medical treatment. And then, as a byproduct or as a consequence of that, then your baby gets the cherry on the cake, which is US citizenship. So they had spoken about this anchor babies where people come in, give birth, baby becomes US citizen. Then in 20 years, 21 years, the baby can file for their parent to get US citizenship, or for the parents to get green cards, and then obviously the parents can also get US citizenship. And they didn't like that commoditization of US citizenship. So Trump came into power. He said no, he had to end this. And so he issued this executive order and said, despite the 14th Amendment, which says that all persons who are born in the US obtain US citizenship, even when they are undocumented, even when the parents of the babies are undocumented. They want to narrow down the interpretation of born with, subject to the jurisdiction, so that if your mother was undocumented or your mother was just lawfully but temporarily present, and the father of the baby was not a US citizen or a green card holder, then the baby was not subject to the jurisdiction of the US and therefore would not get US citizenship. This was supposed to go into effect 19th February 2025. And the executive order said that no department or agency in the US should issue documents to recognize US citizenship or accept documents issued by state, local, or government authorities that would recognize babies who were born to such parents. So if you had, two parents who were undocumented, or one parent who's undocumented along with another parent who's on a temporary visa, like H-1B, L-1, P, O, then the baby wouldn't get US citizenship. Obviously, when you are born in a US hospital, the hospital will give a birth certificate that shows that the baby is born in that hospital, in that city, in that state. Then the parent could use the birth certificate to apply for US passports based on the 14th Amendment or principle of jus soli. But the executive order stated that no more that. Right now, suits were filed against this. People were just angry, annoyed. Multiple suits were filed. As we've shared, several 22 states, city of San Francisco, DC, pregnant plaintiffs, women who were pregnant, they all filed, immigrant rights groups, and they sought to stop this executive order from taking effect. The districts of Hampshire, the federal district court in New Hampshire, and 3 other courts blocked the Trump administration from allowing the executive order to go into effect. And the Trump administration appealed this. The court said nope. So they took it to the Supreme Court and said nope. The Trump administration took it to the Supreme Court and said the district courts could not impose universal or nationwide injunctions. And the Supreme Court agreed with them and said, look, if you want to impose nationwide injunctions, then you got to bring a class action. Following that, they filed class actions. And so this case was the class action suit that was, they tried to certify the group the case to make sure that there was a class action. And now let's go here. Okay, so within hours of the ruling, the petitioners initiated this class action and they were seeking declaratory and injunctive relief for certification number one of a class of all current and future children who are or will be denied US citizenship by the executive order and their parents. And the petitioners were seeking provisional class certification to allow for a class-wide preliminary injunction to stop the enforcement of the order during the litigation. Okay, so the certification of the class is just to group all the members, future babies who could be impacted, all under one, so that when there was a decision given, it could impact everybody. Because the Supreme Court said that if somebody is not named as a plaintiff in a suit or did not sue the government, for instance, then why would you give a relief to cover them? You want a relief, bring your own suit. Otherwise, we need a class action. Put everybody in one, and then we know that you are filing on behalf of everybody. And if there's anything that is ordered, everybody in that class can benefit from that. So that's what they did. All right, so they filed for themselves and other people or other babies who are similarly situated. Okay, let's go here. So even though the plaintiffs in the case, or the petitioners, so the petitioners, I would say, they requested class certification for the babies and the parents, the court in the judgment narrowed down the class to only the babies. They said parents were not, they would be impacted, but the babies were the people who the executive order would deny citizenship. So the court granted it, but just excluded the parents from this class. Yeah. So in order to do this class certification, the Rule 23 of the Federal Rules of Civil Procedure, they had to show that the party seeking the class certification, they are in compliance with the regulations. Guys, we're going to get to more practical things. Please stick with us. This is a little boring, but we're just going to go through it very quickly. I mean, boring for you, I'm sure. Okay, let's see here. Yes, the proof is by a preponderance of the evidence. I highlighted some portions, but I seem to have highlighted almost everything. But yeah, let's see here. Okay. Now, one of the things that they said was that if the class was so large that it was impossible to join all the people who had an issue with this executive order, like a joinder would be impossible, then a class action is a good way to bring or group the people under one umbrella. So they narrowed the class to all current and future persons born on or after February 20th, 2025, where mother was unlawfully present in the United States and the father was not a US citizen or a green card holder, or mother was present in the US with lawful but temporary status and the father was also not a US citizen or a green card holder. And if you see here, it says again what I mentioned, where the class is so numerous that joinder of all members in the suit is impracticable. It's not practical. Okay, so that's it. So yeah, this was granted. Let me just go to page 38. I believe that just as the final order, there's a lot, of things that the courts considered. We won't go into that. The government, arguments that they were also making, but in the at the end of the case, what the judge ruled was that there was a 7-day injunction. And if you realize, 7-day injunction means that this injunction, preliminary injunction, could wear off by 17th July. And the executive order is supposed to take effect 27th July in the states that did not sue, in about 28 of them. We've shared the list of these states that did not sue. But before then, obviously, the Trump administration, they even said it after the court ruling that they were going to appeal. Department of Justice said they were going to appeal this ruling. They will not allow this to happen. And so we're waiting. We as of now, I haven't cited the appeal that the Trump admin may have filed. Maybe it will come in today. We'll see how that goes. So, all right, let me come here. So the judge, as I mentioned, granted a motion for preliminary injunction as to the certified class. So they are doing what the Supreme Court said they should go home and do. All right. Now let's go here. Okay. So yeah, now let's talk about some more things. So we're waiting to see how things happen, like how things will play out, I should say, with this birthright citizenship, because I can foresee this causing a lot of chaos. I mean, just again, if you are pregnant, you're undocumented, are you, people are planning, okay, I'm going to just drive down to a state where suits were filed to block the injunction. If not, nothing changes between now and 27 July. But likely things are going to change between now and 27 July. There's just so many. I mean, I feel like this is a time where there's a lot of, the courts are really being put to work. People are just filing suits, appeals, and the judges are really going through it at this time. Not only are the immigration attorneys going through it, the judges are also getting their share of overtime and being overworked. Okay, we're going to talk a little bit more about what's going on with ICE funding. You guys know the One Big Beautiful Bill Act was passed. It's given ICE a lot of money. CBP over $170 billion. They have a lot of money. Apparently now ICE is the most funded, law enforcement federal agency. So they have a lot of money, more money combined than the DEA, the tobacco agency, and all these other things. Again, U.S. Marshals, we shared all this on our socials. I don't have the numbers here, but 10 times ICE has been given an annual budget of 10 times more than it currently has. So, well, the money they've been given is for between now and 2029. But when you put it together annually, they're going to have a lot more access to funds. So we're going to see a lot more enforcement from ICE. So what we've been seeing, we're likely going to see an escalation of 10 times more. It is certainly a good time to make sure that you are investing in your own future and in your immigration status if you're in the US. I'll say this again, and a lot of my colleagues recommend it, even if you think you don't have the money to hire an attorney for your entire case. At the minimum, make sure you have a consultation with a U.S. immigration attorney who can help you, who has experience, a lot of experience in immigration, and who can actually help you and who's willing to help you. I've seen, many people may not be willing to really help you, but you got to make sure you have somebody who's really willing to help you so that they can help you get your things in order, because enforcement is going to likely be 10x, 10 times more than it is. It's amazing that the Beautiful Bill Act did not give money to USCIS for USCIS to adjudicate petitions. That's where we are needing them to look at, because the concern is that Trump promised, we're going after the worst of the worst. criminals. And yet there's data showing that 65%, according to Cato organization and TRAC, these reputable organizations, only 8% of the people who are in ICE detention have violent crimes, of these undocumented people. 65% have no criminal records. And so they are going after normal, everyday people. I don't know if you guys saw a recent story, DACA recipient. DACA is these dreamers who were brought into the country when they were very young. You know, sometimes some people were brought into the country. They didn't have any passport or visa when they were 2 years old, 9 months old, 3 years old, 5 years old, 9 years old. Obviously, they cannot be blamed for their mothers or fathers carrying them into the country. So Obama introduced DACA to give those people some status to remain lawfully in the US, kind of give them protection from deportation. And I believe this was in Florida, the new alligator Alcatraz, a DACA recipient who came into the US from Mexico as a child. He was arrested during a traffic stop. He has DACA, but this person has been sent to Alligator Alcatraz, the detention center, which is surrounded by pythons and alligators. And this person apparently has no criminal record. He had his driver's license, according to the news article that we saw. And so what is the basis of putting all these type of people in detention and spending taxpayer money on people who are trying to do the right thing, who have status, who have taken care of their status? They have a quota of 3,000 arrests per day. ICE, I believe it's per each US or each USCI. I'm sorry, each ERO field office. ERO is enforcement removal operations. That's a part of ICE. They are the ones who are actually doing the deportations. If they have the numbers, then they're going to be picking up anybody and everybody up. So it's really time to speak up. Make sure that you are sharing some of these things on social media. You are speaking with your elected representatives in your constituencies and states and speaking out. Your community leaders are speaking out against all these things. We shared something from the San Francisco immigration courts this morning. Well, this happened actually yesterday in San Francisco immigration courts. We shared it on our socials. There was a clash that broke out in immigration courts because some people were trying to block ICE officers who were trying to arrest somebody who was coming for immigration court. It's just really, really surprising that these things should happen. Really surprising that these things should happen, because these are obviously people who are trying to do the right thing. They're trying to do the right thing, and they're not being allowed to do the right thing. Okay, so let's see here. Let's see, we have more immigration news. They are ending TPS for several countries, temporary protected status. And temporary protected status is given, to the Department of Homeland Security will designate some countries for temporary protected status protection if those countries have maybe some unrest or some problem that makes it unsafe for their nationals who are here in the US to go back to those countries. They're just trying to end all those things. Currently, I believe there's just about 17 countries that have TPS protection, and a lot of them are already ending. They usually have to extend the TPS, but it does not look like, DHS has already said they're not really interested in doing that. That they're going to make. I remember I saw Christy Noem say that they are actually going to make TPS really temporary, like Congress said. Okay, so Yeah. Okay. So I see. Let me just see this question here. It says, "Did you say the preliminary injunction?" Let me actually share my screen. Hold on. Let me see. Did you say the preliminary injunction was for? Hold on, guys. I'm just going to share my screen here. We shared the actual order by the judge, so we can take a look together. Did you, Joel Rip on LinkedIn said, "Did you say the preliminary injunction will only last for 7 days, or rather, I provide 7 days for the government to appeal?" Okay, let's see here. The order says that it's a preliminary injunction, and there's a stay for 7 days pending appeal. There's a stay for 7 days pending appeal. So simultaneously, the order is stayed for 7 days and pending appeal from the US government as well. So let me just hold on, guys. I'm just going to pull up because I believe we shared. Okay, I think this is it. Oop, not this one. Okay, let's see. All right, guys, bear with me. And yeah, keep dropping your questions and we'll take some questions very, very, very soon so that we can review, see how best we can answer those questions now. Okay, so I found the post that we made. We uploaded a copy of the order that was issued. So let's see here. Okay, so if you look at the order that was granted by Joseph Laplante, who's a district court judge, he said that this was an order granting petitioner's motion for class-wide preliminary injunction. And he said that pursuant to federal rule of civil procedure, this court orders that the U.S. Department of Homeland, the agencies in their official capacity, they are enjoined, meaning they are stopped or blocked and restrained from enforcing the executive order protecting the meaning and value of American citizenship. That is the executive order that proposed to end birthright citizenship. So the court requires a nominal bond of $1, and this preliminary injunction is stayed for 7 days pending appeal. Okay. All right. So they've been, blocked for 7 days, and then we're also pending appeal. So okay. All right. Let's see if we have any more questions. There's a lot going on, you guys, and there's now immigration has become even more complex. It's encompassing some constitutional law, some civil litigation. So it's really not, and then in addition to the immigration aspects that we're dealing with. So yeah, let's all keep working and learning together as all this unfolds, because it's honestly a learning curve for many attorneys and everybody, in fact, everybody, because all these things are, a lot of them are unprecedented, and we're all learning and seeing how things unfold, and, sharing our knowledge and just taking feedback and, getting the law tested and seeing how things will play out. All right. Now let me take off this. Okay. Alligator Alcatraz, we have, there's information that there are very inhumane conditions. That was the goal from day one, that the place was flooded. I understand there's extreme heat, infestations, limited contact, and there's no information as to whether they're even getting any outside time, being able to shower. Apparently, that detention center in Florida is controlled by the state of Florida instead of by federal government. And if you all remember, in January, Trump also shut down the office that was supposed to oversee immigration detention centers. That was supposed to make sure that immigration detention centers are following, I'm sorry, are following certain standards that have to be met. They shut down that office. They shut down the ombudsman office, and then there was another type of detention oversight agency was also shut down. So now there's nobody to check anybody. You know, they can do what they want, and you only have your family and your attorneys to try to fight for you if you are caught up in these things. The other thing is also, you guys, we shared on our social medias the effect this is likely to have on food production, grocery prices, and other things. You know, there were some reports in California and other states that some of the farmers, they could not even get people to milk the cows, feed the cows, pick strawberries and pick some of these fruits, and they were going bad. The secretary of Agric, is it Rollinsbrook, she said that they wanted to move towards 100% American legal workforce, and so undocumented farmers, nope, they're not going to do any amnesty. They're going to get them out of here. In the next breath, Trump will say, oh, he wants to help farmers, and then the next time somebody says, no, we're not doing anything. It's quite confusing. And I believe there's a lot of industry, agricultural industry leaders that are pressing the administration, because apparently a lot of the farm owners are sponsors of the Republican Party. So these are people that own acres of farms, own businesses, and they rely on undocumented immigrants to do the work. Now, many of these people are not showing up. We shared statistics of these on our social medias. Some of the farms, 70% of the farmers are no longer showing up because many of them don't have status. And even for those that have status, even if you have a green card, you are not necessarily safe because, depending on your history, do you have any criminal record? Have you gone to say anything that makes you a threat to national security? All these people are very uncomfortable. And even for the green card holders, for instance, who don't have any criminal record or anything, they're just uncomfortable being raided with ICE, with the way they're acting. They're even detaining US citizens. So what is the guarantee that if I'm a green card holder and you come and raid a farm, you're not going to pick me up? People have families to go back to. And so if I'm going to risk getting picked up at the farm, then I won't go at all. I just had a consultation, and we've been having a lot of these consultations, from school teachers who are telling us that, well, now the elementary schools are on vacation. But I just had a consultation with one school teacher, an elementary school teacher, who was telling me even before they went on vacation, many of the students stopped coming. They stopped attending school because moms are afraid, dads are afraid to take their children to school. I saw a report from MSNBC a couple days ago. People are not going to be going to school once school reopens, but even before, because schools just had the summer vacation, they realized that pre-K, elementary school, they were not going to school. 20% increase in absences because the parents are thinking that if I take my child to school, maybe in the afternoon when I have to go pick them up, I will not be there. I'll be arrested by ICE. But let's go back again to the farm discussion, because the argument that is being made it's a very plausible, very sensible argument. If you are looking for criminals or the worst of the worst, immigrants to detain and deport, those type of people are not on farms working hard. You won't find those people on farms. The people you're going to find on farms working hard are people who are generally honest, hardworking people. So why go after these type of essential workers? That's a question for them to answer, but it does not look like they're slowing down Tom Holman, I saw him say a couple days ago that they are not slowing down, they're going to continue with what they are doing. And it's obviously going to get worse. So it is certainly a very good time to make sure your immigration status, you've invested, speak with an attorney. For us, our consultations are cutting edge, very good and helpful. And once you contact us, we will assist you to figure out what you need to do. It's worth it. It's very interesting. Sometimes we'll have people, they will buy plane tickets. When they are buying plane tickets from wealthy airline companies, plane tickets of $2,000, they don't ask the airline company for discount. Or, oh, I'm a student, or, oh, I don't have money, so can you let me fly for free? But when they're coming for legal advice from a small company or a small law firm, which cannot be compared to an airline, then they are trying to get free services. So it's an investment you make in your own life and in your own future. Okay. So make sure that if you are here, you can speak with an attorney and get something going on. Louisa Ashanyaku says, hi, I'm almost out of status on H4. Can my mom, a green card holder, file for me and my oldest daughter? Yes, mom can file, but it doesn't mean that will protect you from falling out of status. H4 means you're the spouse of an H1B, and mom can file for you so long as you're not married. But so let me say generally, a parent who is a green card holder can only file for their unmarried children. So if you are married, it looks like you are the spouse of an H1B. So if you are married, then that's going to be a problem. But contact us so we can get more information and see how we can assist you. Okay. Richard Figueroa says, I got my R130 approved already. Oh, that's good. Please contact us. TPS from Honduras since 1998. What are my options? You do have a few options. Please get in touch with us and then we can review them together and assist you. Okay, Jeffrey Osei Mensa says, you are doing great, Ikuya. Thank you so much from LinkedIn. I appreciate it. Which immigration court is better, New Jersey or New York? There's a lot of legal analysis going on. People are trying to forum shop. Please contact us and let's see what you really need and how we can help you. Okay, let me see if I can get a couple questions on Instagram. Ibn Saki says, what of those with 5-year B1, B2 visa? Do they still have single entry? It looks like you're from Ghana. No, if the new law is not, or the new rule is not retroactive, it doesn't go back. So if you have a 5-year visa, you can still proceed under those original terms. That means you have a multiple entry likely, and your visa expires when it actually expires. The new rule does not affect you until you are going for a new visa. Okay. All right, guys. So let me see if I have anything. Okay. One Rahim on TikTok says, has anything changed with the green card process, like files or prices now with the big Bill Beautiful Act? Yes, we've shared a lot of the fee changes that have come into effect with the one big beautiful Bill Act law. We shared all, we shared all the new fee changes. I'm trying to pull it up from our social media so I share with you guys, and that happened. Please forgive me. Let me see. Yeah, so there's new fees, and these fees are in addition to already existing fees. Now, the green card holder process has not necessarily changed. These fees have more to do with people who are filing cases in immigration court and they're filing appeals. Those are the kinds of new fees we're seeing. And there's currently a lot of confusion. Immigration courts some of them are rejecting cases because they don't have the new additional fees. And yet USCIS has not given a way to make those payments, EOIR. So there's a bit of confusion going on there. So until they can set up the operational system, or they can operationalize how these fees can be paid, then we have to figure out what to do. Some of the courts are saying they are taking some of these cases pending confirmation of the additional fees being paid. Okay, so I'm going to share my screen. I've been able to pull up our social media where we shared the new fees. Okay. All right, let me share here now. Let's take a look. Okay, so this is from our Instagram. It's also on Facebook, same post. Now, if you look here, the fees are already in effect, and there are immigration-related provisions, new fees for various immigration-related applications. These fees are usually in existing to, in addition, to existing fees. So if you look at asylum, now asylum applications are $100. Previously, it was free. You have to now pay an initial $100 fee for initial asylum, which is a humanitarian application. And each year your asylum application is pending, you pay $100. It's not waivable. Initial EAD for asylum, $550. Renewal, $275. If you're applying for parole, then $1,000, $550. So all these fees are there. We've shared all these things on our social medias. Then the visa integrity fee, all these are again minimum amounts. They could set higher amounts. I-94 fee, then immigration court filing fees if you are doing an adjustment of status in court, an additional 1,500 in addition to the 1,440 fee. But there's again more confusion because some of the some people are saying they are seeing just the 1,005 fee. So they will clarify all these things because, again, as they work to operationalize these systems, there's going to be some of these lapses until it can be sorted out and then things can go on properly. So these are the fees: cancellation of removal, you pay an additional 1,500. Appeals, we've shared this and several other posts about the fees on our social. So you can certainly take a look there. All right, guys. If we don't have any more questions, let me hop off. And you guys, if you haven't followed our social media platforms, please make sure you give us a follow. Let me see if we have a couple more questions. Make sure you follow our social media platforms. And if you have enjoyed the session so far, please drop us USA. Let me make sure you guys can still hear me. And I'm not just talking to myself here. Please drop USA or put in the US flag here. Kimi Boss says, I'm an F1 student and recently applied for my OPT, but it hasn't been approved yet. However, my husband is a US citizen in the military. So do you think I should file for my green card? What's the timeline? This is a good question. Yeah, you should certainly apply for your green card based on your marriage to a US citizen. He's in the military. That's always really helpful for you. You came in on an F1 visa, so you were inspected and admitted, and it means that you can adjust your status in the US. You can stay here and get a green card without leaving. Please contact us to see how best we can help you. We handle a lot of these type of cases, and we represent immigrants in all 50 states in the US. Now, with a timeline, we are going to do something called a concurrent filing. It means we apply for the foundational petition, the green card, work permit, and if you want a travel permit. We don't advise travel at this time, but you are free to apply for all those things. Once we submit your application, in about 3 weeks, you get a receipt notice from USCIS. It has a 13 alphanumeric number, and then you can track the status of your case on our systems and on USCIS portal. And then in about 3 months, you get a biometrics notice. You got to do your fingerprint, your eyeball picture, and your signature. The US government wants to make sure you don't have any criminal background or you are admissible. As part of the process, you also do your medicals, which will submit with the initial application to make sure you are not inadmissible based on health grounds. And, so after you do your biometrics 3 months after submission of your application, then you could be called for an interview in about 8 months, 7 months, 10 months, sometimes 12 months. And you go with your spouse to meet an immigration officer at the USCIS field office. Start to finish could take about 15 months, could be less. For some people, if they mess up, you could get something called a request for evidence. Sometimes you may not mess up, but the government wants to clarify certain things. So they could send you a request for evidence to submit something else or clarify something. Now, if you are doing an adjustment of status, this is a time to make sure that you're doing the right thing. Work with an attorney or law firms that do this very regularly, because they're able to catch errors and they can help you easily. Now, there's a February 28th memo, February 28, 2025, that says that if your case gets denied and you are out of status, you'll be sent to immigration court. The immigration courts are now so backlogged, it's not even funny, but they're sending more people there. Now, ICE has been given money to build more detention centers, $45 billion to increase detention capacity. So they're planning to increase detention capacity to more than 100,000 beds. I believe currently the capacity is under 44,000 beds. Now they want to go to 100,000, and they're hiring more ICE officers so they can do the work. They're hiring more ICE officers. They are going to give bonuses to ICE officers. So it's not a time to play around with your immigration application and end up in immigration court. It's really not the time to do that. Yeah, sure, you can take the chance, but it could go well or it could also not go well. Okay. So Kimi Boss on Instagram. I hope that was helpful to you. Let's see if we have another question on Instagram that we can answer before we go. Guys, drop USA if you can still hear me and you're enjoying the session. I think we are done with answering some of these questions. So hopefully we're going to see you in our next live video. Don't forget to follow our social media pages. We share a lot of insightful information. So follow us to ensure that you are up to date with what's going on. Okay, Gloria says, Gloria Enchel on LinkedIn says, I'm an international student. I'm currently facing financial difficulties because my scholarship is not being paid. I'm also at the verge of being out of status. My dad is a US citizen. I wanted to know if my dad can file for me. If dad is a US citizen, then he can file for his daughter. There are 2 categories of filings he can do. He can either do, so let me give the general 3 categories. He can either file for you as an immediate relative who's a daughter of a US citizen, but you have to be under 21 years old. That is an amazing category to be in because there's no wait for visas. You don't have to wait for visas to become available. Then second is under the F1 as the unmarried daughter of a US citizen, not the F1 visa, F1 preference immigrant category, adult unmarried daughter or son above 21 years old of a US citizen. Then we have the F3 category, which is the married daughter or son adult of a US citizen. So he could file for you there, but you want to be careful because there are some rules about maintaining lawful non-immigrant status if you are being filed for under the preference immigrant category, as opposed to if you are being filed for under the immediate relative category. Your visa overstays will be forgiven. You can get a green card if you are the minor child of a US citizen, parent of a US citizen, spouse of a US citizen. If you are in any other category, you must generally maintain lawful non-immigrant status when you apply for the green card. So there's a lot of timing issues you got to be careful of. Please set up a consult with us and let's help you with what you can do with that. Edward Ochri Edward Ochri she says, if I apply for an F1 renewal in different countries, say Canada, will this affect me as a Ghanaian? No, you just got to make sure Canada will, F1 is obviously a non-immigrant visa, and Canada will accept will allow you to go and interview there. I remember in 2024, Department of State issued an advisory and said that they were one global organization. I even shared a video on this on our social media. They were one global organization, and so if there were backlogs in one country, then people could use other consulates around the world to apply for their non-immigrant visas. When it comes to immigrant visas, however, they take a different view that you can't try to transfer your case in order to circumvent lengthy wait times. But for non-immigrant visas, they encourage that you could apply from any consulate where you feel you qualify. You can submit an application, and you should be that should work. You should just be able to show that you have ties that will compel your return to your home country, and you have all these other, you're coming to pursue a full course of study in the US. You can pay your tuition and all these other things. Hissen Rastaman says, I'm a DV lottery winner. My interview is coming soon, but my country is under travel ban and our gouvernement engaged dialogue with US government. Do you advise to not lose hope and pass the interview? Which country are you from? Togo or some other country? Yes, those 19 countries that were banned, they are being issued with the denial after the visa lottery under Section 212F, that they cannot be issued immigrants visas based on the travel ban. But yes, don't lose hope. Just you always have to keep hope alive, because immigration law is fast changing. Anything can change. Anything can change. Anything can change. Anything can change at any time. So, okay, you're from Chad. Okay. Anything can change. So let's see how things go. When do you have your interview? I wish you all the best. I mean, this visa lottery thing breaks my heart, because visa lottery is a once in a lifetime opportunity, guys. People tell me, I mean, once you win visa lottery, you might never win it again in your lifetime. So when you win it, you don't joke with it. You gotta pursue it with all you've got. So things can change. There's a lot of dialoguing going on the diplomatic level. A lot of these governments are trying to talk things out with the US government to see how they could reduce some of the visa bans. And that's why this recent visa restrictions imposed on several countries like Ghana, Nigeria, Ethiopia, Cameroon. I've been saying that, well, we will take the visa restrictions over travel bans, because the travel ban can really destroy a lot of plans and goals and ambitions and dreams. So the travel restrictions, or the visa restrictions, I should say, they are certainly better than a total ban, or a total immigrant visa ban, or even a total non-immigrant visa ban. They've just reduced the extent to which you can enter the US on most of the non-immigrant, non-diplomatic visas. Okay, I was trying to pull up the the total, the first June 2025 travel ban, the 19 countries that were banned. Let's see. Oh yeah. So actually, so Chad even has a full travel ban. Yeah, he's saying Chad has a full travel ban. So that means your government has a long way to go. We posted the justification for each country that was banned. If you guys can see right here, Chad has extremely high visa overstays, indicating disregard for US law. Oh gosh, yeah. Oh my gosh, yeah. This was one of the ones that I found so striking. Student visas are overstaying people from Chad when they come on student visas, they're overstaying by 55.64. More than half don't go back. B2, B1, B2 visa is 50%. Half of the people, super high. Wow. Entry fully suspended for Chadian nationals, immigrant and non-immigrant visas. Well, again, looking at these stats, I don't know if I have hope for Chad. These are very, very, very high numbers for your country. So, well, let's see. Maybe your government has very good skills to negotiate, and maybe they could do something about it pretty quickly. Yeah, okay. So Prince Fiajibe says exactly my thoughts. Reduced validity periods of non-immigrant visas are better than full or partial visa bans. Absolutely, yeah. Yeah, it's certainly better because if they had banned B1, B2 visa issuance or student visa issuance, which they can do because the US government will tell you it's a privilege to get a visa, not a right. So if they had banned it, the whole countries, all these affected countries would have been somersaulting by now. But you have the restrictions. So if you want to come in, you come in, do what you can do, and you go. All right, guys, I'm about to hop off. Jojo Graham, last question. Can a B1, B2 holder receive status change through fiancé or marriage? B1, B2 cannot receive status change through fiancé. If you're B1, B2 visa, the fiancé visa process is for people who are based abroad outside the US. Then your fiance can file a fiance petition, and then it progresses, and you can get a K1 fiancé visa, single entry. You come in 90 days, you get married, and you get your green card. But with change of status, you can do it's not a change of status. You can do an adjustment of status if you are married to a US citizen or green card holder and you are in the US. Change of status is changing from one non-immigrant status to another non-immigrant status, like B2 to F1, B2 to L1, B2 to H1B, for instance. But adjustment of status is changing from a non-immigrant status to permanent status, like a green card. So you can change from B1 to a green card holder through marriage. They are trying to crack down on this as well. All right, guys, thank you for joining. Please like our page, follow us when you see our posts and our videos, comment, share, and push our engagement so that the people that need us can get in touch with us. They can see what we are also doing, and perhaps they could benefit from the information we're sharing, or be able to reach out to us when ICE knocks on their door or tries to take them, or they have any issues. Thank you all so much for joining us. It's been a pleasure meeting with all of you guys again. I look forward to meeting you guys next week, hopefully 1 p.m. Now, this year, we are doing much better. Last year, we weren't doing too well with our lives because, but we're doing much better. We're being consistent. So we picked a date. Friday, we picked a day, Fridays at 1 p.m. to engage with you all and see what questions you have, to see how we can also assist in our own small way. We appreciate each and every one of you. And I'll see you guys soon in our next live session. Okay, take care, everyone. Bye bye.